Hi, as I'm sure many of you know, this week is Family Mediation Week, and you will have no doubt seen that there are some fantastic talks that have been arranged this week by the Family Mediation Council that are aimed at promoting mediation and a greater understanding of it as a process and the benefits. And these talks are aimed at lawyers, mediators, the general public. So if you haven't checked them out, then do go onto the Family Mediation Council website. I do believe that they are being recorded so that they are also being released after the week. So for any of you that don't catch them this week, you can hopefully watch them at a time that's more convenient. The reason I wanted to jump on was something that struck me in relation to the questions that I often get asked, or the main questions, I often get asked from family solicitors about the hybrid mediation process. And it's often, okay, I understand how it works, but why would we not just do a roundtable meeting? And it is a really good question. And so I thought that I would jump on and just give you what I feel are the main reasons, so my top 10 reasons as to why, as lawyers, you may advise your client that it would be better to participate in a hybrid mediation rather than simply a lawyer-client roundtable meeting. So the first one, and this is an obvious reason, that the parties are already in mediation, so they may already be in a very traditional mediator-client mediation, two-party mediation, and actually they've got to a point where they feel that they would benefit from the support of their lawyers and to evolve the mediation into a hybrid, which might involve including other professionals, and also the ability for the mediator to speak to each party in separate spaces and hold confidences. And so it is important that the lawyers then support the clients in that process and enable them to continue to feel that they're in control and feel empowered that they're working towards a resolution, but with the support of their lawyers. So important not to do anything that might trigger that process to break down if actually it is really benefiting the parties and it's something they want to continue. Number two, power imbalances. And so, you might find yourself in a situation where there's quite clear power imbalance between the parties, and actually having a mediator there who can help address those power imbalances and ensure that both parties feel able to actively participate in that mediation, and so the mediator can adapt accordingly and ensure that it's most effective, and both parties are getting something out of it, and I think that reduces the risk of it breaking down quite quickly if it was simply a round table. Neutrality. So obviously the mediator doesn't have a motivation in terms of trying to get a particular outcome for either party. Their motivation is facilitating and helping them get to that resolution. And so that neutrality can be really beneficial, not just for the participants, but I think for the lawyers as well. Having somebody there who is looking at it much more holistically and how to support the family as a whole, I think is really can be really beneficial, and also gets parties away from positions and makes the whole process, in my view, less adversarial. Venue, so for quite a practical reason, the mediation would take place in a neutral venue, so the mediator's office most commonly, and again that can just help making everybody feel like they're on equal footing. Next one I've got down is case management, so the mediator can and does help set the agenda and also how to progress the case, and again that might involve bringing in neutrals. And so I will often, before I've sat down with the parties and their lawyers, meet with the lawyers, so we can agree a plan on how the case will progress in mediation, what experts we want to bring in, at what point we want to deal with any disclosure issues, how, the format of the mediation, the structure, and that planning is so important to ensuring that session is as effective as possible, leaving nothing to chance. And so again, that can be really helpful, and particularly for the lawyers who often haven't been engaged in that process before. And actually it can be really helpful for the lawyers to have that meeting without the clients at that point. Sometimes the lawyers, they've corresponded, they've never actually spoken, and so it can really set the tone for how we want the meeting to go. And so that kind of leads me on to my next reason, which is sort of keeping the lawyers in check and setting boundaries, being really clear about their expectations of them. And we expect the participants in mediation to come with a real commitment to seeking a resolution. We expect the exact same from the lawyers in that process. And so it's about trying to create a team approach, a very collaborative approach, recognising that obviously the lawyers are there to advise and support their individual clients, but coming at it much more with a team approach, that we are all committed to trying to help them to get a resolution. So I think that's really important. And I sort of covered two there, so kind of the collaboration and the keeping lawyers in check. Confidences, so I explained at the beginning, the mediator can keep confidences, and so that allows them to speak to the parties separately, understand, what are the priorities, what are the needs, kind of what are the parameters, and knowing that helps the mediator to work with the parties in terms of, again, looking at the multitude of options, reality testing those options, finding common ground where there might be common ground, and helping the parties to explore, well, if that is a potential option, how do we make that work? Really looking and finding those avenues towards solutions and need, and rather than being stuck in positions, and building up trust with both parties can be really, really beneficial. Whereas obviously when it's just a round table meeting with the lawyers, then you've very much got a case where one lawyer knows their party's position and parameters, the other lawyer knows the other, but there isn't, sometimes that can, if there's an impasse, the meeting can very quickly break down by not understanding the potential scope for moving it forward, in my view. Being able to be more reflective, and that's where the mediator comes in, getting each participant to understand where the other party might be coming from and why something's important to them, why that's a priority, why that's a need, and as I say, going back to that reality testing, what does that actually look like? And so hearing that and being able to say, right, well, what does this mean for the other person? Rather than it just being a case of each party, as I say, just putting forward their position and disagreeing with the other person's position. Actually, let's flip it, let's be more reflective, and again, ensures that the meeting is likely to be more effective, less likely to break down at an impasse. So the kind of reflective approach that the mediator brings to a meeting is really important. And so those are my top 10 reasons why I personally feel that a hybrid mediation can be a more effective way of reaching a resolution. That's not to say a hybrid is needed in every case, and there are reasons why just conducting a roundtable meeting between the lawyers and the clients is the most effective way of dealing with things. And I know that when you're looking at things like cost, that's often a reason why you may decide, or the clients may decide, that actually we're just going to have a meeting with our lawyers and not pay for the additional cost of having a mediator. But I do feel in many cases the benefits and what a mediator brings to that meeting is often actually much more of a cost-effective way of getting to a solution more swiftly than having an ineffective roundtable that ends up feeling very positional, very adversarial, breaks down, and actually sometimes can take the parties further back rather than moving them forward. But if any lawyers have any questions, any family lawyers want to speak to me a bit more about the hybrid mediation process, or you're still not sure as to why you would do it, what the benefits are, always happy to have a chat. And as I say, at the start of any hybrid process with the involvement of lawyers, I would always propose there is a planning meeting with the lawyers before the 5 of us even consider having a session together. And as I say, 9 times out of 10, this is the first time the lawyers have been involved in a hybrid, so it can be really advantageous and beneficial for everybody involved. So yeah, that's it from me. I hope you enjoy the rest of Family Mediation Week. Bye-bye.